Good morning. Got all my instructions now. Let's see if I can try not to mess it up. Um, so I won't talk too much more about myself. I mean, that was more than I normally ever say. So you guys already know me pretty well. But um, hopefully, I can keep everyone awake. Starting, first thing in the day with the lawyer talk. I guess it's better. Maybe sometimes last of the day, people are starting to fall asleep. I don't know when the perfect time to talk is, but we all had coffee, so we're okay. We'll be able to do it. Um, so my subject, what I was really asked to talk about is this kind of broad topic, protecting assets while pursuing Medicaid. But more broadly, we're going to really spend this hour talking about how Medicaid benefits can help families dealing with dementia and how you can protect your home and other assets while pursuing those benefits. But I'm going to kind of do it in a certain framework. I didn't have time to do a top 10 list like David Letterman, but I have a top 6 list because I only had 60 minutes. And I thought I'm probably going to talk at least 10 minutes on every question, but I can't even do that because I'm going to try to save a little time at the end for your questions. So, really, I'm going to frame this hour around the top 6 questions that are often asked in my conference room. And I'm thinking that that might be a guess as to what questions you guys might have if you were sitting in my conference room, or what your clients might ask if they were sitting in our conference room. Because these things just come up all the time when we're working with families who are dealing with issues of dementia, looking at long-term care, curious about Medicaid, that sort of thing. So that'll be kind of the framework for today. And like I said, I'll do my best to leave some time after my 6 questions to see what questions you guys have. So the first question, let's start with this. I've been told my husband needs long-term care because of his dementia. Does that mean he must move to a nursing home? If so, how are we supposed to pay for that? Well, this is the question that I listed first just to kind of ease our way into the long-term care conversation. Something that I've learned through the years of doing this is that there's a lot of different preconceived notions about what long-term care even means. There's a good subset of the population who just equates the word long-term care with nursing home care. That's all there is. If someone is told they need long-term care, that must mean they need a nursing home. Well, I want to make sure that we're clear on this, that that's not really what that necessarily means. It might, but there's all different levels and all different versions of long-term care that might be appropriate depending on the particular needs of the person. So typically we start the conversation by mentioning that there are a lot of good home health options, home care options. There are a lot of good companies in Northwest Arkansas and all over Arkansas, actually, that can provide help in the home. And there can be a lot of variety there. I mean, there's a lot of different types of care that might be provided in the home. But just because someone is told they need long-term care doesn't necessarily mean they're going to be leaving the home right away. Home health might be an option. Another option that is not as overlooked now, but when I started working in this field was very overlooked. People didn't understand the difference between assisted living and a nursing home. Nowadays, assisted living facilities gotten much more well known and understood. But there was a period of time that people just thought it was, and now there's still some folks who come into my conference room who don't realize there's a difference. And we spend quite a bit of time at the beginning of our meetings talking about the difference between assisted living and a nursing home. It's as much a medical or care discussion as it is a lawyer discussion as to whether nursing home level care makes more sense or assisted living care makes more sense. I'm not usually the guy that's going to tell you which direction you need to go. But we would like to be the ones, if the family doesn't already realize it, to talk about there are more options than they may realize. And then if you spend a lot of time, we can talk the rest of the time just about assisted living because there's all different types of specializations inside of assisted living. A lot of facilities will have independent divisions, assisted divisions, memory care divisions. And so it's just the point being you want to do your homework. If you are in a position that you're going to be looking at facility-based care, there's a lot more options than you might think. And then typically the highest level care is nursing home care. So certainly that is sometimes what is meant when someone says you need long-term care. But all of those options are going to seem expensive, I'm sure. And so people are going to ask, well, how are we going to pay for that? So I have a story. I've been in this position. I mean, I guess I say I probably can't really claim that. I was probably in high school when most of this was going on. But my parents, my dad was helping his parents through this situation many years ago. So if I was high school, it would have been the 90s for me. So, costs were a little bit different then, but my grandpa really, really needed to be in assisted living. My grandmother probably did too. They were actually the kind of couple that probably, it just seems like it happens all the time, where one spouse is physically pretty well, but starting to lose some capacity from a mental standpoint, and the other spouse is mentally sharp but physically getting weaker and unable to do things. So as long as they were together, they might be able to work it out. And so my grandfather was the one who was physically getting weaker and unable to do things, and he had to go in for a bypass surgery, and he went in. The main reason he agreed to go to the doctor, because he never went to the doctor, the main reason he went in is because he couldn't mow his entire yard in one day in his late 70s. He said, something must be wrong. I can't work my garden and I can't mow my whole yard. So he went in and finally agreed to do the bypass surgery. And after it was over, he declared the whole thing a complete failure because he still couldn't mow his whole yard in one day. And so that was bad. But my dad started looking into assisted living for him down in Central Arkansas, and did the thing where you come in with all the brochures and have all the information and told him, let's talk about this. I've done some visits. I want to take you for a visit. And he said, he heard him out, and he said, well, just how much is this going to cost me? Because that's what people, one of their first questions. And my dad just kind of vaguely said, it's going to be about $3,000, just something like that, And he about fell out of his chair. He was not a very animated person. He's a pretty serious guy, but he about fell out of his chair, and he said, son, we have a paid-for house here. How am I going to go spend $3,000 a year to go live somewhere else? So, my dad knew this is not gonna work out. So it was one of those scenarios where the children provided most of the care. My dad had two siblings, and so the three of them did most of the caregiving in the home, which, that's pretty common. Eventually, after my grandfather passed, then my grandmother did have to go into assisted living. She wasn't going to be able to stay there alone. And then she had a stroke while in assisted living and ended up in a nursing home. So we've been through the whole spectrum, from the home health all the way through the nursing home. But again, even after my grandfather died, when he thought assisted living was $3,000 a year, even though my grandmother had dementia, she was always very, very worried about money and, concerned about that. So, how are we going to pay for that is a big question. So, what we'll spend the rest of our time talking about, well, there's three ways to pay for long-term care. You can pay out of pocket if you just have plenty of money to do that. You might have long-term care insurance to cover that, but the point there is Medicare and your Medicare supplements and those sorts of things are not long-term care insurance, so you can't count on that. So you might have enough money to just private pay out of pocket. You might have long-term care insurance, but if you don't, then the questions we get asked a lot are, is there a way that Medicaid can help? And again, that was kind of the biggest point of me being here today, so we'll talk about that. So that kind of leads us into question two. I don't want to disregard the home health or the assisted living areas because the answers I'm going to give you today would apply there, but I was trying to bring up the 6 most common questions I have. So one of the most typical scenarios where someone might come see me is question 2. The nursing home admission staff told us that we should look into Medicaid, but I feel like we're wasting our time. Don't you have to be broke to even qualify for any kind of help? Well, it is true that Medicaid benefits are very different from Medicare. Most people who walk in our doors already have Medicare. There's no financial restrictions on that. But Medicaid, it is not wrong to think that there are strict income and asset limits for Medicaid. That's absolutely true. But it's an exaggeration to say, oh, you have to be broke, you can't have anything to get Medicaid. So where I want to start with this question too is the asset test. That's kind of the way this is phrased. You can't have anything if you're going to expect any kind of help from Medicaid, right? Not true. Now, the asset rules for Medicaid are very different for a married couple versus a single individual. So let's start with that. You might have heard some rules from friends or family or a well-meaning social worker somewhere who has dealt with this with a single person. And so you're hearing all the single person rules, and the married couple rules are way different. So you want to know that first. But no matter whether it's a single person situation or a married couple situation, The asset rules leave a lot more flexibility out there for planners than you might think. So we don't have time in this little bit of, we're not going anywhere, right? So maybe we have all the time we want. Y'all don't want to leave now. Started pouring. We don't have time to go through all the different planning techniques. They're so case specific. But from a big picture standpoint, like the introduction in my law school class, what I would say in the first 15 minutes kind of deal is that for a single individual, usually what we're going to look at is this framework where you can have a house, you can have a vehicle, you can have prepaid burial arrangements and things like that. And otherwise, you can have $2,000. That's where this question comes from. What, don't you have to be broke to get any kind of Medicaid? $2,000, not a lot. And in my class, I have learned as I'm reading these cases with my students that I haven't looked at in a long time, that this $2,000 limit hasn't changed in decades. This was $2,000 decades ago, and it's $2,000 today. There's been some other changes in the law, but no flexibility in that limit. So that's why people think you have to be broke to get Medicaid. First of all, they're thinking about the single person case, not the married couple case, but still, that $2,000, that'll scare you off. But what you have to understand, and we're going to talk about this more in connection with another question, is there are absolutely planning techniques that can allow you to preserve assets while getting to that $2,000 level. So hold that point for another question here in a minute when we talk about gifting rules and things like that. But don't decide on your own that you're not going to look into Medicaid or research it because you've heard, oh, you have to be broke. I guess this is never going to work. It's definitely worth looking into. For a married couple, there's a lot more options than you might think. Whereas the rules are as strict as they are strict on the income and asset rules. There's an entire area of the Medicaid manual that is the spousal protection rules, designed to help a spouse, still have assets and income to live at home when the other spouse is entering an expensive nursing home. There's a whole area of law on that. So do you have to be broke to qualify? Well, maybe, but does that mean you have to be broke when you walk in the lawyer's conference room door? No, there are definitely things that can be done to help preserve assets, and that's what elder law is all about. Now, another question, though, that we ask, I get all the time, I've been told my dad makes too much income each month to qualify for Medicaid. So maybe a person doesn't have just a tremendous level of asset, but they've been told that they have too much income for Medicaid. Well, again, that's based in fact, that's based in accurate information, but it's an exaggeration, it's an overstatement. So there is, in fact, an income limit for a Medicaid application for the applicant. First thing to note, if we're talking about a married couple, again, on a married couple case, they can't even consider the income of the spouse who may be staying at home. We're just talking about the income of the applicant. But there is an income limit for the applicant, and that does change every year. It's up to $2,825 a month. Now, they're looking at your combined total gross income. So that throws people off sometimes. They'll report their Social Security deposit. Well, we've done this long enough to know that there's probably a Medicare premium being withheld out of that. So when they tell me what they make from Social Security every month, I can probably assume that's not their gross Social Security benefit. And sometimes people's pensions and retirement checks have deductions as well. So Medicaid is looking at your gross total income when they look at that limit of $2,825. But there's this story many, many years ago, not here in Arkansas, nothing to do with me, but a guy named Miller went to court and said, this is the dumbest rule ever. This cannot be the law because my income exceeds the current income limit for Medicaid, but is nowhere enough to pay for long-term care. So how can this be the Medicaid law? This makes no sense. So some judge created a device called a Miller Trust and named it after Mr. Miller all these years. And we still call it a Miller Trust. That's not really technically the name in the Arkansas Medicaid manual. We call it the Irrevocable Income Trust in the manual, but everybody refers to it as a Miller Trust. The point of that is that no one should ever be denied Medicaid because their income is too high if they just know how to maneuver the program, because it is not a creative, brilliant elder law device to utilize a Miller Trust to get around the Medicaid income limit. It's laid out in the statute. It's laid out in the rule book. You just have to know it's there. You just have to know that you have to utilize that. So you might say, well, what is this Miller Trust? Some people misunderstand and think a Miller Trust is how you save assets. If your assets were over the limit, I'm going to park some of them in a Miller Trust. No. That's why it may be good to know the full legal name of this. It's the Irrevocable Income Trust. It's only designed to deal with income. But the way it works is it's not overly complicated. If your income is over that 28, 25 level, but you're still wanting to pursue Medicaid, you create this trust, which in its most basic essence is a bank account. Now, probably at whatever bank you normally bank at. It's nothing special. It's just a regular old bank account. And it's going to operate as a funnel where your income, which would have otherwise disqualified you for Medicaid, funnels through this Miller Trust on its way to cover your patient liability, whatever your responsibility is for cost of care. And as long as your income goes through the Miller Trust on its way to wherever it's supposed to go to spend on care, the income limit is disregarded by Medicaid. So it's basically an acknowledgement that Mr. Miller was right, the guy that brought that lawsuit however many years ago, that it is a silly rule to have an income cap if the income cap is so much lower than the typical cost of care, because there would be so many people caught in that gap. And so the Miller Trust is just a hoop to jump through that the courts and eventually the statutes were created to acknowledge that was a problem and this is the way around it. So that's kind of how the Miller Trust works. So if a person ever thinks they have too much income for Medicaid, that's actually the least of our concerns. Usually the assets that I talked about first are a little bit more work for us to deal with, but the income problem shouldn't be. Now, I do want to point out here, I usually try to talk about income in this scenario here, that even though Medicaid is a great benefit, the way it works is the applicant for Medicaid typically has to use the majority of their personal monthly income towards the cost of care. Not all of it, but most of it. And then Medicaid will make up the difference. So we know right now that the average price of a nursing home in Arkansas is, based on just statistics, is about $8,500 a month. So if a person had $2,500 a month of income, then they would contribute most of that $2,500 of income towards the cost of care and be looking at Medicaid to make up the difference. But that's not always true. And I said earlier, there's all these spousal protection rules. Sometimes there are instances where we can veer off some of the applicant's income and let the spouse keep some of the income. There are certain deductions like health insurance premiums and drug plan premiums that can still be covered out of an applicant's income. But all that happens kind of in the background of this Miller Trust situation. I mean, those rules apply whether you're utilizing a Miller Trust or not. The Miller Trust is just the way to save the day if the income was over the limit, like I was saying. All right. Now, what was our next one? Question 4. I heard if you give away any assets before filing for Medicaid, you're denied benefits for 5 years. Is that true? Well, one more time, that is something that people hear in the community. That's something that a lot of people think. And there is some sort of factual background to it to make that rumor persist. What I mean is, there is in fact something called a 5-year look back in Medicaid rules. Sure, that's true. But the 5-year look back does not mean if you've gifted or transferred assets that you're denied Medicaid for 5 years. Doesn't necessarily mean you're denied for 5 years from the time you made the gift or 5 years from when you file for Medicaid or whatever you may be thinking. The 5 years is not the length of time that you can't get Medicaid if there are gifts involved. The 5 years is simply the window of time through which the Medicaid folks are allowed to view what you've done with your assets. That's why they call it a 5-year look back. When you file for Medicaid, whether you're filing for a nursing home or assisted living or home health, when we started, we talked about all the different levels of care. Whenever you file for Medicaid, no matter what type of Medicaid you're filing for, one of the questions on the application is, have you given away or sold anything for less than fair market value in the last 5 years? That's the 5-year look back. But if the answer is yes, that doesn't mean they're going to throw your application in the shredder and say, well, then you're out. It just means that there are certain formulas that they're going to run. There's some calculations that they're going to do. to determine if there's going to be a period of time where you're not going to get benefits, but it's typically not 5 years. So the way that works, every about $8,500 in gifting equals a 1 month penalty period or waiting period for Medicaid benefits. And you might think, you keep saying the number 8,500. Where's that coming from? Well, the state does a statistical analysis every year to determine what the average price of a nursing home is in Arkansas. This year, it's about 8,500. And that means this year, the penalty divisor for that formula that I was talking about is 8,500. So that changes every year. So basically, if a person were to give away a vehicle worth $8,500 right before they filed for Medicaid, Medicaid might approve the application, but make them wait 1 month for coverage because they gave away an $8,500 asset. Then you might ask, well, what if I say I sold it? Well, if you say you sold it, that's different from what if I sold it. If you say you sold it for $10 or whatever, that's not going to work because Medicaid looks at fair market value in transactions. So that's why the question really is, have you gifted or sold anything for less than fair market value? That's what they're asking. So people, will transfer their house to their child and put $10 on the deed. So they'll say, oh, I didn't give away my house. I sold it to my kids. Well, not really. They're really looking at anything that you're calling a sale has to be a true fair market transaction. So, so if there was gifting, then it doesn't mean that you can't get Medicaid for 5 years, but it does mean that Medicaid's going to impose a transfer penalty or a gifting penalty for whatever you've transferred. So one of the numbers I can remember kind of off the top of my head is like $100,000 gifted is right about 1 year of a Medicaid penalty. $200,000 is about 2 years. So that seems like a long penalty, and maybe it is. But if people walked into my conference room thinking that gifting equates to a 5-year denial for Medicaid, then usually what I have to say about it is a lot better than what they came in thinking. Now, there's one more rule that you should know about that gifting penalty that can make things even better. And that is, if you get penalized for 1 month for every $8,500 you gave away, what does Medicaid do if this child or family member or whoever got that gift, if they use those assets to help pay for your care, does that have any impact on the gifting penalty? Yes, it does. So if $8,500 given away adds 1 month to the gifting penalty, $8,500 given back towards the cost of care knocks 1 month off the gifting penalty. So what that usually means is someone could actually give away $150,000 worth of assets to a trustworthy caregiver child, apply for Medicaid, and they would actually get a approval back saying they're going to have to wait a year and a half for Medicaid because $100,000 is a 1 year wait. So $150,000 would really be a year and a half. But the way the formula tends to work is if that child uses $50,000 towards the cost of care over the next several months, the penalty will actually come down from 18 months down to 12 months. And the person will become eligible for Medicaid, and that caregiver child still has $100,000 of that money set back. So it gets complicated. That's why we usually have marker boards in our conference room so we can actually do the math on the board for folks. But the point is that the gifting rules, although they're very important, they are out there. It's not as bad as people think. It's not this 5-year wait just because you gave away an old pickup truck. And it doesn't mean that a person can never get Medicaid. And so normally with a single individual in need of care, we're actually utilizing the gifting rules on purpose. We're telling the family, you have two choices. You could just privately pay for care till these bank accounts are depleted to $2,000. Or we could be more proactive. We could transfer some of the assets. We file for Medicaid. We know they're not going to give you benefits the very next month after we file because we've just transferred assets. We're not hiding it. But you're going to be on Medicaid a lot sooner than you thought than if you had just private paid till the money all ran out. So this is an asset protection mechanism. It seems like it's a strict rule. The gifting rules sound like they're really bad rules, but we can actually use them as a tool towards getting eligibility while protecting assets. Okay. Now we rarely, on purpose at least, would do any gifting with a married couple because, as I said earlier, with one of the earlier questions, there's all sorts of spousal protection rules in the Medicaid manual that we can use to shift assets between spouses, and there aren't gifting penalties when you shift assets between spouses. So there are other mechanisms we might use for a married couple that don't even implicate the gifting rules. Now, the gifting rules apply in every kind of case. So if someone walks in our door as a married couple and they've already done some gifting, we don't say, "Oh, no problem, you're a married couple." Well, no, the gifting rules still apply. We might still have a penalty because of gifting that maybe was done before we ever met the family. But we don't usually utilize gifting as our asset protection mechanism. For a married couple, we use the married couple spousal protection rules. But for a single individual, this is usually the way that we handle it. Here's now, it really scares people. I've heard about Medicaid. I've heard about people filing for Medicaid, and then as a result, they lose their home. Is there a way to avoid that? One more time. This is not a made-up question. This is not a stupid question. There's enough basis in fact for someone to ask this, and it's right for them to ask. But it's slightly overblown and exaggerated. So what this question gets at is there is a process in Medicaid that the federal law requires every state to have some version of estate recovery in their manual. Estate recovery basically says if a person gets Medicaid benefits while they're living, and if they pass away owning assets, the state of Arkansas has to attempt to recover those assets to recoup the money that was spent on care. Estate recovery. Now, it's not usually a big issue because how many times have we said in the 30 minutes I've been talking that if you're going to be on Medicaid, you're not going to have a lot of assets. That's the whole point. We're either going to gift those assets or we're going to shift them to the spouse. We're going to do something because we have to deplete the assets in order to be eligible for Medicaid. So a lot of times a person on Medicaid is going to pass not owning a lot of assets, but you can have a home and get on Medicaid. So the most likely asset to be subject to this concern about estate recovery is the home, which is why this question makes sense. So people have heard that their aunt or their neighbor or their whoever got on Medicaid, and then when they died, for some reason they, quote, lost the home. Well, they might not know it, but they're talking about estate recovery rules. So the state of Arkansas does, in fact, have a right to attempt to put a lien against any property that you may own when you die if they paid Medicaid benefits on your behalf while you were living. They do. But now Arkansas, we're lucky in this area that Arkansas just has traditional basic estate recovery, which means they can only attempt to recover against those assets that pass through probate court. Now, other states have more creative estate recovery, where the state can go try to tack on to all sorts of assets that the applicant may have had while they were living. But let me kind of bring this home. For the home, the house that you're trying to protect, one of the best tools to get this off your mind and know that the state cannot take your home is something called a beneficiary deed. A beneficiary deed is a mechanism for saying who gets the home when you die without it going through probate court. Now, if your home doesn't go through probate court, well, that's good right off the bat. Nobody wants to be in probate court anyway, but it's doubly good for a Medicaid recipient because now you've protected your home from probate court and from this risk of Medicaid liens. So one good thing about teaching this law school class is I'm actually learning some things because I realized every time I give a big reading assignment to my students, I'm now giving myself homework because I have to read it before class. And what I have realized is I've never really studied other states' laws, but there's a lot of states that have expanded estate recovery. And in their rule book, it says that the state can go after property that might pass on through a beneficiary deed. But they can't do that in Arkansas. And we're very confident in that because that's actually a somewhat recent law change. Up until just a few years ago, Arkansas law did give the state of Arkansas the right to put a lien on property that may pass under a beneficiary deed. if the person was on Medicaid while they were living. But that was not what most states do, especially not the neighboring states around us. So someone convinced the legislature that we're the outlier here. We need to get in line with the other states and get rid of that law. And we did. So this was a law change that was very favorable to the population, to the citizens. Because previously, when the law said that the state could put a lien on your property, even if it avoided probate with the beneficiary deed, this was a much more scary question. Do I even want to go after Medicaid? Well, if I do, am I going to lose my home? And we'd have to talk about those gifting rules and say, well, if you want to make sure you don't lose your home, maybe we have to gift it. And there's a lot of negatives that come with that. But we had to just weigh positives and negatives. Are we going to gift the home? I don't know. Now we don't have to. Now we can set up the home with the beneficiary deed. And using that beneficiary deed, we can make sure that, again, it won't go to probate court, which is good for everybody. We all should think about that. But it protects that home from Medicaid liens. So that's great because setting up a beneficiary deed is not subject to the 5-year look back because you're not gifting your home. So if you set up a beneficiary deed the week before you enter a nursing home, that's okay. It's not a penalty situation. You didn't gift your home. You just set it up inside a beneficiary deed. It's more of an estate planning device. So there's no 5-year look back for it. There's no penalty for it. Now, and you haven't really given it away. So all the benefits of inheriting a home still apply. What do I mean by that? Well, this is a little bit beyond the scope of today's talk, but if you just give your home away to your kids, they're going to receive it in an unfavorable tax situation. Where as you owned your own home, if you sold it, you wouldn't have to pay capital gains taxes on that in a typical case because there's an exemption for all of us homeowners. We can sell our home free of the capital gains tax. If you give your house to your kids and they sell it, they do have to pay capital gains tax, and they have to pay it on the difference between what they sold it for all the way back to whatever the basis of mom and dad was that gave it away. So for someone that's owned a home for decades and then they give it to their kids, they're setting them up for a major unpleasant tax surprise. The kids also are not eligible for the homestead tax credit on the annual real estate tax bill, the over 65 freeze. And there's a lot of negatives that can come with just giving your house to your kids. But sometimes in the past, people who were filing for Medicaid had to just weigh and balance the benefits and the negatives and decide maybe they have to just do it. But now they don't have to do that. And this beneficiary deed idea, all that negative tax talk I was talking about doesn't apply because your kids are just inheriting the home. And in that instance, they do receive it in a favorable tax position, and they're not going to have all those negatives. So I'm a big advocate for the beneficiary deed nowadays because it was always a good device for probate avoidance and putting yourself in a better tax situation. But now that it's a shelter against Medicaid liens, it's, the win, 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 win. It's good all the way around most of the time. But that leads me perfectly into question number 6. And we're doing great on our time, so I will have time for some questions at the end. So question number 6 is, we don't really need long-term care just yet, but we want to be ready in case we do in the future. What should we do now? Well, one of the things I would give serious consideration to would be that beneficiary deed. Now, again, I said the beneficiary deed is not subject to the 5-year look back, so you don't have to do the beneficiary deed 5 years before you need long-term care to make it work. But I also said the beneficiary deed is helpful even if you never need long-term care, just for probate avoidance. So you might consider setting up some form of a beneficiary deed early on, or at least maybe I should expand that and say, do something to make sure that you're not putting your family at risk of probate court. So it might not just be a beneficiary deed. It might be a beneficiary deed. It might be a revocable trust. It might be beneficiary designations on your bank accounts, beneficiary designations on your IRAs, beneficiary designations on your life insurance. We might not, statistics say 70% of folks who reach the age of 65 are going to need long-term care at some point in their life. But statistics also say that we're all going to die one day. So planning for probate court is super important. Long-term care is likely, but not certain. But we're not going to be around forever, right? And so what should we do now? We want to think about this whole estate planning thing and avoiding probate. And if we want to tie that back to this Medicaid conversation, we want to remember that Medicaid can put a lien on anything that winds up in probate court. But we don't want to go to probate court anyway. But especially if we're trying to prepare for the future possible need for long-term care, then probate court becomes especially dire and something we definitely want to avoid. So perhaps we do that beneficiary deed, and maybe we do a lot of other things. But all those things will be geared towards making sure nothing winds up in probate court. So that's one of the things you can do long before long-term care is needed, because that's applicable to anybody. Another thing that might be just as important, but sometimes overlooked, power of attorney and healthcare power of attorney documents. So a lot of people, say a married couple, will come in and say the husband is dealing with some dementia issues and the wife is not. And I start talking power of attorney, and they say, well, I'm his wife. I can do whatever, right? Like if anybody needs to sign or make a decision, like we're spouses, I can do whatever, right? Wrong. The reason people might think that is asset by asset, that could be true. If you have a joint bank account and one spouse needs to go make a withdrawal or write a check, they don't require the consent or the signature of the other spouse. So in managing a joint bank account, can one spouse manage it if the other's dealing with dementia? Sure. But that's just specific to that particular asset. Can one spouse sell a house? No. Both spouses have to sign at closing. And if one of them can't, that would be okay as long as there's already power of attorney documents in place. Now, a spouse can't automatically make withdrawals on the other spouse's IRA or manage investment decisions on an IRA. I can't even think of everything that a spouse can't do, but there's a lot of things that a spouse cannot automatically do if they don't have power of attorney. And right now, I'm just talking about general financial run-of-the-mill power of attorney. So even in a married couple situation where there might be this false sense of security that, oh, I can just rely on my wife or my husband to do whatever needs to be done, that's not the case. Power of attorney is very important in that instance. But healthcare power of attorney is important too. I will say that probably in the typical small town medical scenario, a healthcare provider will probably be more comfortable speaking with the spouse about healthcare issues, even if there wasn't a power of attorney. But if it got real serious and someone had to make a life or death decision or sign a waiver or sign a consent or things like that, they're going to really want power of attorney to make sure they're protected and you're protected. So some lawyers will kind of blend and merge general power of attorney and healthcare power of attorney into one document. I mean, there's nothing illegal or wrong about that. We typically do it as two separate documents. So we're not trying to put too much in one power of attorney document. And to facilitate, if you maybe want one person to be your financial power of attorney and someone else to be your healthcare power of attorney, two different documents, that's a lot easier to accomplish. So those are some really crucial documents that I would consider, anybody ought to have. In fact, my wife made fun of me. My son turned 18 just a few months ago. And we didn't, he's too cool for a big birthday party these days. So we didn't have a big party. But on the night of his birthday, we did have some cake and whatever food he wanted. And right after we blew out the candles, I disappeared for a minute. And everybody's like, where's Pat going? And I came back out with power of attorney documents. And I said, all right, buddy, you're 18. You have to sign these. And it turned out like I was actually kind of proven right, because he had a few doctor's appointments set up just, a few weeks or months after he turned 18. And the doctor would call and our numbers would be on there and I'd answer, or my wife would answer, and they'd start talking and say, wait. Are you James? No, I'm his dad. Oh, we can't talk to you. He's 18 now. So, I mean, even for children turning 18, power of attorney is important, much less for a young at heart person turning 80, power of attorney and healthcare power of attorney is one of the things. It's not expensive. It's not complicated. So even if you don't know you're going to need long-term care one day, but you're just trying to think, what can I do to be ready? Absolutely do that. And then shift it over into that probate conversation. Just like the Medicaid planning conversation, the probate conversation varies widely from family to family. Someone might come in with a house in one bank account. Now, a probate avoidance conversation can be short and sweet. Someone comes in with a house and 3 rent houses and a commercial property and CDs and all these other assets. Well, okay, maybe it's a longer conversation, but it's still the same conversation. We need to avoid probate, just how we're going to do it. That's the point. So basically, I think that's kind of my summary. I will say one thing. I'm only going to spend like 3 minutes on this, but it's a common point of confusion, and it is one of the things someone might do in advance in answer to this question. So there are actually 2 types of trusts in the world. Well, there's a lot more than 2, but big picture, there's 2. There's a revocable trust, which is what most people have, but there's also an irrevocable trust. So if someone is extremely concerned about long-term care and they kind of have a lot of assets they're trying to protect, then we might talk to them about doing an irrevocable trust, because a revocable trust is great for avoiding probate, but it doesn't shelter assets from Medicaid analysis from long-term care, because a revocable trust is just considered your asset if you file for long-term care one day. Because revocable means you could always just do away with the trust and take all the money back with one signature. So a revocable trust is not really a Medicaid plan, it's more of a probate avoidance plan. So if someone has the right mix of assets and their concerns, their top level concern is long-term care, we probably talk to them about irrevocable trusts, because an irrevocable trust is not an available asset when you file for Medicaid one day. But there's a lot of pros and cons that come with it. If your number one concern is, I want to lock up some assets so that Medicaid can't count them, then that might outweigh all the cons of an irrevocable trust. But if you're kind of on the fence and you're like, hey, I would like to have a lot of flexibility and control over my estate plan, but I also want to be sure I'm protected from Medicaid, well, then there's not a clear-cut decision, because it's kind of one or the other. You don't have flexibility and control in an irrevocable trust, and you don't have Medicaid protection in a trust that includes flexibility and control. So we'd have that conversation. But I didn't want to get out of here without mentioning that there are multiple kinds of trusts out there, and one is considered an asset shelter for Medicaid. That does have to be set up 5 years before you file for benefits, or it will factor into that gifting penalty that we talked about. So that's kind of how that works. The most typical scenarios where I've used that has been, for instance, someone will come in, they have a house, they have some assets, but they have this family farm down in South Arkansas that's been in the family for generations. They never want to lose it. They never want to see it go anywhere. Well, that family farm is going to make it real hard to get Medicaid, because it's a countable asset. It's not their homestead, it's a countable asset. But they sure as heck don't ever want to sell it. If they just give it to the kids, we've got this negative tax situation, all of that. So that's a great scenario where we might set up that irrevocable trust to put the farm in there. But we don't really have to put the home in that trust, because the home's an excluded asset. We could use the beneficiary deed for that. That's one scenario where it's come up lately where we've used something like that. So it's very fact specific, but it is something that's out there. So I had 60 minutes for 6 questions, but I think I only used 45 of those minutes, so I can answer other questions. And, I do teach a law class on this, so I could sure talk for 14 more minutes if y'all don't come up with anything. But I would rather talk about things that y'all want to hear about. So if I'll pause for a minute and see if there's any questions, I'll repeat the question so everyone can hear it and answer it. And if not, then I'll come up with something to talk about myself. Yes, ma'am. Because of long-standing health issues, and the only asset he has right now is a car. You're wondering if you need to do something special with the car, and you're not power of attorney, which adds a little bit of to the question. Okay, so the first thing I would say is that it's not extremely urgent that you do something with the car, because anyone on Medicaid can have a vehicle. And so the vehicle in and of itself is not going to kick him off of Medicaid. Even if you were to pass and he was now a single person owning a car, a single person can still own a car and be on Medicaid. The reason you might want to be proactive and get his name off the car is that he said he doesn't drive. If one day you wanted to sell the vehicle and your name's not on the title, it might be a challenge for you. If you're not power of attorney, it would for sure be a challenge for you. So there could be some reasons that you might want to change title on the car, but not necessarily because the car is going to kick him off of Medicaid. Typically in Arkansas, vehicles don't wind up in probate court either. as long as there's not other probate assets. It's just that one item of personal property. So it's not a huge concern for me. And it might be difficult for you to change the title since you're not power of attorney. I'm glad that you mentioned that, though. I do need to say one thing. I'm a big advocate for power of attorney. If you can get power of attorney, I want you to consider getting it. But a person signing power of attorney has to have capacity to understand what they're signing and to willingly grant that authority. So if we're already in a position where there's too many health issues to really, in good faith, say that there's a valid signature, then there's one other thing that you might do in advance. So it's kind of a last resort. It's not something you want to jump right to, but there is a process in Arkansas, the guardianship process, where a court can make you guardian over a person when power of attorney is not an option. Now, it's a lot bigger deal to go see a judge and have a judge enter an order making you guardian than someone just signing a power of attorney, which is why we say power of attorney is something you want to do in advance. Because if you can do it before there's too many health issues, that's way cleaner than guardianship. There are instances when guardianship just can't be avoided. And this could be one of them. So I don't know that you would rush down to the courthouse to get guardianship just to deal with the car. But if you're not power of attorney and you're not on the title, then that might be the only way that you could do something about the car. But I'm glad that you brought up the question because I didn't mention guardianship in connection with the power of attorney conversation, and that is one of the options. There is a lot of paperwork in a court hearing in front of a judge. Yeah, it's kind of a big deal. That's why we make it a last resort. But it is a lifesaver for some families if they really needed some authority, but it was too late to get power of attorney. Yes, ma'am. Yes. Now, if you are planning far enough ahead, the question was, can I speak to long-term care insurance and how it relates to what we've been talking about? I am a big advocate for long-term care insurance, actually. The negatives that are associated with it are kind of obvious in that, number one, just like anything else in the world, kind of expensive. So some people will get quotes and say, oh my gosh, I can't afford that. And I think, well, if it avoids you having to pay for long-term care, that's even more expensive. But some people will shy away from it because of cost. Other people can't pursue it because they wait too late. There is medical underwriting required with that. Now, it's a little different analysis than qualifying for life insurance because these companies are managing their risk on how risky they think it is that this particular applicant's going to need long-term care. Whether a life insurance company is deciding how likely it is that you're going to die soon. It's a totally different analysis. But there is that issue that you have to make it through medical underwriting in order to get a policy. Then you get your fee quote and see what the premium's going to be, and you have to decide if you want to sign up for it. But if you can get through medical underwriting and you can afford the premium, it can be a good option. For example, some of the great assisted living facilities in Northwest Arkansas don't accept Medicaid, but they all accept long-term care insurance because really long-term care insurance goes to you to help you pay for your care. So it would open up more options for a person for different care choices if you had insurance to cover it and you didn't even have to worry about all the Medicaid rules we talked about. It's still similar to Medicaid in that you have to medically need the benefit to trigger it. Some people have a complaint about that. They'll have a long-term care insurance policy and their doctor will suggest they need assisted living, but their company that they have the long-term care insurance with doesn't think the need is bad enough to trigger the policy. So you want to be real aware of the terms of the policy and what it takes to trigger it so you don't have some unpleasant surprise when you're trying to trigger it. But all in all, if I ever have a client come in who has long-term care insurance and they're asking, should I keep this? Is this even worth it? I can't think of a time when I've said, get rid of it. Usually I'm glad you have it. Let's keep it at this point. So I think it's a good thing. It's just, and there's so many different kinds of policies out there now. Used to, people didn't love long-term care insurance because it was kind of a use it or lose it type of a deal where it's kind of like auto insurance. You pay all these premiums, but you hope you don't need the policy because that meant you had a wreck. But if you don't need the policy, then all the premiums are just gone. Well, that's how most long-term care insurance used to be. Well, now they have hybrid policies where you can have a death benefit attached to it. So if you never need the policy for long-term care, then you can have a death provision as to where it goes at the time of death. So that takes away the use it or lose it concern of long-term care if you look at that kind of policy. Great question. Yes, sir.
You execute a beneficiary deed for it 2 years after they sidewalk self-problem.
Yes, sir. Good question. So the question is, if I have a beneficiary deed, I've signed it, it's notarized, I filed it at the courthouse, and then later I decide I want to sell my house, am I going to have a problem? No problem at all. The beneficiary deed, by its very terms in the deed, says it's not effective till you die. And you have every right to do anything you want to with it before you die. Even execute a new beneficiary deed. Say you left the home to one person with your first round of estate planning, and you change your mind and you want to leave it to someone else later, you can go revoke the first beneficiary deed and do a new one. Or you can just revoke that beneficiary deed and sell your house or do anything you want. So that's a great question. And that's another positive of the beneficiary deed is it's very flexible. It doesn't lock you into one path or one plan. Now, what about an LLC? Well, that's a very short, outrageously broad question. Okay. So in the Medicaid world, an LLC is not usually going to be a huge help because, well, if you set it up where you used to own this set of assets, and then you set up an LLC that you own and you move those assets into that LLC and you own the LLC, well, then you still own the assets just in a different way. So it doesn't necessarily help you reduce your assets. Now, if you say you had your kids set up an LLC and they own it and you move the assets into the LLC and they own it, well, that got assets out of your name, but just as long as you're comfortable with the fact that now you don't own those because you don't own the asset, nor do you own the LLC. So that's kind of like the irrevocable trust I mentioned. It's a way to get some assets out of your hands as long as you're comfortable that you don't have control or flexibility anymore, then an LLC could be used for something like that. Now, I see your wheels are turning, so it's a good question. The question is, what if the wife owns the LLC and the husband was the one who might be in need of care down the road? Unfortunately, and I'm extremely glad you asked that question because I didn't make this point very clearly when I talked about the strict asset rules earlier. I did in the income side. Remember, I said only the income of the applicant counts on a Medicaid application, not the income of the spouse. But I stopped there. And what I should have continued on and said, but on the asset conversation, all the assets owned by either spouse get thrown into the mix on the application. Now, again, there's a lot of spousal protection rules that a spouse is allowed to keep. But when you file that application, you can't just report the assets of the applicant who needs care. You have to report all the assets that are owned by the husband, owned by the wife, owned jointly, owned by the husband and the daughter, owned by the wife and your cousin. Yeah, everything that either spouse touches in any way has to be addressed. So the LLC idea, it wouldn't work to have the husband transfer his assets to an LLC owned by the wife because we'd still have to report the wife's assets. It would have to be someone other than the couple. It'd have to be maybe the children own the LLC or something like that. Yes, ma'am. Is it considered gifting if you transfer to the children? Yes, it is. So whether you set up an irrevocable trust owned by the children, an LLC owned by the children, or you just simply gifted the asset straight to the children, in any scenario, it's basically if you used to own the asset and you used to control it and now you don't, no matter what mechanism you use to make that transaction, if you used to control it and now you don't, then it's treated as a gift. So if it was done 5 years before the need for care, maybe we're fine because it's out of that 5-year look back. But if it's done within the 5-year look back, it'll have to be reported and potentially penalized. And divorce doesn't help it either is the comment. Well, the only time for one, I don't push or advocate for divorce just for Medicaid purposes because there are a lot of other reasons not to get a divorce. But even if someone came in predisposed to say, hey, I'm up for it, let's just split up if that'll protect assets. Well, Medicaid sort of insists that the divorce be managed by the book. So basically what I mean by that is that typically there's supposed to be an equitable distribution of assets between the spouses. And if you go in and it was kind of like a fake divorce and you're like, hey, I'm the one that needs long-term care, just give everything to my wife. And you get a friendly small town judge, it's like, okay, you must have your reasons. Well, DHS can look at that and say, this looks a little shady. That doesn't look like a normal divorce. Now, the only time that answer would be different is I have had success doing that, not my idea, but the client insisted, when there was a pre-existing prenup. Because then if the judge divided the assets in an uneven way, there was justification for it. Because there was a prenup that said, if we ever get divorced, wife keeps all these things that she brought into the marriage and husband will gets what he brought into the marriage. And so there, DHS doesn't have much room to complain because the statutes told the judge to follow the prenup if it met the law. But if you just try to pretend like you had a fake prenup, that you're just saying, hey, we don't have a prenup, but just give everything to my wife. I don't want anything in my name. Probably not going to fly. But that, too late. You're not pre anymore. Yep, too late. All right. Well, I think that we've probably reached the end of our time. We do have a table back here, and my friends Brad and Will are here. Oh, my last slide has our information on it. There we go. I didn't say thank you. There, thank you. So I have some flyers and brochures and business cards at the back. Some friends here with me that can answer questions. So if you didn't really want to ask your question out, in front of everybody, there's still a chance to chat. And most attorneys like me, I'm not the only one. Most attorneys like me are typically willing to do a free initial consult to really dive into your specific situation. So don't hesitate. That's my biggest takeaway is do your homework, ask questions, make sure you're not going off assumptions like those 6 questions were. Make sure you have the real answers as they apply to you so that you're making good decisions. So thank you very much.